Hello, a good day to you, depending on where you join us today, and a heartfelt welcome to our session, the implementation of the HCCH principles on choice of law in international commercial contracts. My name is Yael Weiner. I'm a Senior Director at the Office of the Deputy Attorney General at the Ministry of Justice of the State of Israel, and I'm joined by my colleague from Uruguay, Mr. Marcos Dotta, to discuss how the HCCH principles continue to be used as a model or inspiration for interpreting choice of law regimes at the national level, including through case law, as well as for the modernization of national laws. So indeed, as set out in the preamble to the principles may be used as a model for national, regional, supranational, or international instruments, and may be used to interpret, supplement, and develop rules of private international law. They can be applied by courts and by arbitral tribunals. Both Marcus and I have some experience or witnessed how the principles achieve these goals, and we will share this experience in this session. And therefore, Marcus will kick off the discussion to explore from the viewpoint of policymakers how the HCCH principles influence the national and regional choice of law regimes. And so now I'm happy to give the floor to you, Marcus. Perhaps you can briefly introduce the relevant frameworks in Uruguay's legal system and your country's position on the HCCH principles.
Yes, of course. Many thanks, Yael, and greetings to all of you from Montevideo. My name is Marcos Dotta, and I'm the Director of International Law at the Ministry of Foreign Affairs of Uruguay. It is our pleasure to have this enriching discussion on the implementation of the HCCH principles. The principles are designed to promote party autonomy in international commercial contracts, more specifically endorsing that the party's choice of law should be respected. As such, the principles enhance predictability and legal certainty as to the law governing the party's transactions, which are important conditions for effective cross-border trade and commerce. In the meantime, the principles set out reasonable boundaries to party autonomy, such as public policy and overriding mandatory rules. The principles are soft law in nature, thus they are not formally binding, but they provide a comprehensive blueprint to guide users in the creation, reform, or implementation of choice of law regimes. I have to say that in any case, it's always interesting and impressive in international law how international custom can become a source of law. In relation to my country, as you may know, the Parliament of Uruguay has presently passed a new private international law, which is in force since March 2021. Perhaps its greatest innovation is the reception of the principle of party autonomy to choose the law applicable to international contracts. And this is the perfect field where our private international law system aligns with the HCCH principles. In this sense, the general rule is now, according to Article 45, that international contracts are governed by the law chosen by the parties, and that parties may choose generally and internationally accepted norms as a set of rules neutral and balanced. This is a wording obviously inspired by Article 3 of the principles, which allows the parties to choose not only the law of a state, but also rules of law emanating from non-state sources, something that should be highlighted. As you know, historically, choice of norms or rules of law has typically been contemplated only in an arbitral context. The same disposition of our current private international law states that references to a national existing law may be interpreted with exclusion of conflict of law rules, which is aligned to Article 8 of the principles as it excludes the renvoi. In addition, our law recognizes express and tacit choice of law as Article 4 of the principle does. So I am in a position to say that our Congress has incorporated the principles to our legislation, having also in mind other inspirational sources as the Inter-American Convention on the Law Applicable to International Contracts approved in Mexico in 1994 and Rome I regulations. This is the legal situation in Uruguay. Yael, what is the relevant framework in your country's legal system? And what is Israel's attitude towards the HCCH principles?
So thank you, Marcus. It's really interesting to hear about the legal situation in Uruguay and your position regarding the principles. For us in Israel, the legal system is a hybrid of civil and common law traditions. So in general, choice of law rules in civil and commercial matters in Israel, they're not found in legislation, but were rather developed by Israeli case law. So for example, Israeli courts generally tend to respect the law of the contract as a leading choice of law rule. However, notable exceptions can occur when the law of the contract might be determined as part of a adhesion contract, where the parties are of disproportionate bargaining powers, such as the consumer contracts, or when the court determines that the law of the contract is contrary to public policy, both of which are in line with the HCCH principles. But I have to say that these are very rare cases. In recent cases, decision by courts not to apply the law of the contract were, when it was explicitly included, were subsequently overturned by higher courts. And in light of the nature of our legal system, Israel does not formally intend to adopt the HCCH principles and not through legislation. At the same time, we do consider the principles as a useful document reflecting common conceptions on choice of law in international commercial contracts. The principles are an important guidance tool on choice of law in international commercial contracts, complementing the 2005 Choice of Court Convention, which Israel has recently signed and is in the process of ratifying. Considering that the 2005 convention provides a framework for addressing choice of court by parties, the principles offer guidelines for choice of law by parties in contractual settings. So together, these two texts provide a holistic framework offered by the Hague Conference on Private International Law for adjudicating disputes arising from international commercial contracts. Our office, the Office of the Deputy Attorney General for International Law in the Ministry of Justice, oversees all commercial private international matters, including litigation and relevant clauses in commercial agreements between government entities and foreign and international commercial parties. And in this respect, we often look to the principles for reference and guidance in determining choice of law questions in international commercial contracts. Some of this use is routine, as in the cases of providing guidance for drafting choice of law clauses or highlighting to government entities that in most cases a foreign choice of law clause carries with it various implications in accordance with the principles. And other cases are more complex and involve submission of position to Israeli courts. Maybe I can elaborate on this a bit later. So as we discussed, Marcus, the HCCH principles can spread their influence and achieve the goals set out at the beginning of the project in different ways. And how do you anticipate further influence of the principles in Uruguay's legal system?
Yes, thank you, Yael. As you mentioned, one of the goals set out of the outset of the development of the principles is to serve as an inspirational for national or regional modernization of law. Indeed, this has been the case in Uruguay, and as we have seen, this inspiration resulted in a very recent new private international law. At this time, all practitioners are studying and starting to implement the new dispositions, very excited for the challenge that seems to have a baby. As the new private international law recognizes practices and principles of international contractual law of general acceptance, or recognized by those international organizations to which our country is a party, as is, of course, the HCCH, I really look forward to seeing the implementation of the principles in case law in the near future, as especially how the new choice of law approach will work in coordination with a principle of choice of courts for contracts that was already regulated within Mercosur in the Buenos Aires Protocol. Yael, you mentioned earlier that some of the use of the principles in Israel involve submission of positions to Israeli courts. Can you elaborate a bit more on this, please?
Many thanks, Marcus. I think it will be indeed interesting to follow the developments in your country and to see future use of the principles in case law. In Israel, the principles have been referred to in order to assist judges in deciding cases. Israeli courts have had the opportunity to address choice of law issues in various cases, and in recent years, the Attorney General referenced the principles in several positions submitted to the Supreme Court, which is the highest judicial instance in Israel. So, for example, in a case involving the company Hotels.com, as most of our audience probably knows, Hotels.com offers hotel rooms for rent across the world and is accessible in several languages, including in Hebrew. And likewise, for users in Israel, the prices for the rooms are advertised in Israeli currency. However, in the case brought before the courts in 2017, the plaintiffs noted that the prices in the Israeli version of their website did not include the required taxes for Israeli citizens, despite being advertised in a seemingly all-inclusive manner. So unlike in the United States, Texas, which was the applicable law according to the original contract, the law in Israel requires that prices of products, including tourism-related products, be shown inclusive of all applicable taxes. So the plaintiffs' customers of Hotels.com claim that the practice of presenting prices in Israel's currency without including the taxes was misleading, and that the company should compensate Israeli customers for this. And in addition to that, the plaintiffs also claimed that the choice of law clause in the contract, as I said, which applied Texas law, was an unfair contract term in standard form or adhesive consumer contract, and therefore should be disregarded by the court, and that Israeli law should be applied in its stead. And on the other side, Hotels.com argued that the Israeli court must respect Texas law, and that if the claim was to be adjudicated by an Israeli court, the court must apply Texas law. So due to the importance and the implication of this legal question that the case presented, the Attorney General decided to submit his legal opinion to the court. This is a prerogative of the Attorney General according to Israeli law. And the Attorney General supported the consumer's claims regarding the choice of law clause. And the opinion submitted by the Attorney General emphasized the imbalance of powers between the supplier and the consumer, even more so as international commercial interactions between large corporations and international consumers become more and more common. And in support of this argument, the opinion also referred to the HCCH principles as widely accepted practices in which consumer contracts are excluded from the general rule of choice of law to provide legal protection to consumers. The proceeding was discontinued, so the court did not rule on the Attorney General's submission. However, just a couple of weeks ago, the Israeli Supreme Court has for the first time specifically referred in a judgment to the principles as guidance in a case involving foreign choice of law clause in a contract dispute. And I will just elaborate a little bit on this. It's an interesting case. The case pertained to a suit filed by an Israeli fashion business against Facebook in a dispute concerning Facebook's advertising services. According to the contract between the two parties, the applicable law was that of the state of California. The plaintiff argued that the clause was an unfair term in a standard form contract and therefore it should be disregarded by the court. After hearing the case, the court found by a majority opinion that under the circumstances, the clause was indeed discriminatory, emphasizing that despite the fact that both parties were corporations in this case, due to the power imbalance between the two, the issue of an unfair choice of law clause is still relevant. And in its opinion, the court made reference to the HCCH principles and to the exclusion of consumer contracts from their scope. So these were two examples in which the exclusion to the principles were used to assist the courts in deciding cases. But I must say that, and as I noted earlier, the substantive provisions of the principles are often used by our office as a source of guidance, reflecting contemporary global practice. And just a short example for this, in a case where the Israeli government contracted with a packing company for warehouses services in the United States, The plaintiff was another company which lost its bid to provide the services, and the company claimed that the Israeli law and jurisdiction should apply even though the tender proposal and the contract referred to New York law and New York courts. And in this case, the state's position aims to reflect the principles in order to support the application of New York law to the contract, and the courts upheld the government's position. So as we near the end of our discussion, I think it's clear to say that HCCH principles on choice of law in international commercial contracts can be utilized as an important tool in the work of different jurisdictions. And I invite you, Marcus, to conclude the discussions. What are your takeaways from our discussion today?
Well, many thanks, Yael, for sharing your thoughts and points of view on the principles during the session and for these very interesting cases of Israeli courts. I think that it is clear that the HCCH principles are an example of how the international community can benefit from the work of our organization and how the dialogue among different legal systems result in positive, clear, and useful outputs for everyone. In this sense, I think that the principles may be seen as an international code of current best practices related to international commercial contracts, along only 12 articles that synthesize in an easy, understandable, and balanced way rules that are considered acceptable by the international community. They are soft law, but a soft law flexible and very well grounded. In a world where many times borders divide, the HCCH principles are bridges. Thus, I would like to encourage, first, the knowledge of the principles, should this be necessary, and then the use of and the reference to these principles by all the stakeholders, professors, judges, arbitrators, legislators at all levels, and of course, traders and businessmen and businesswomen, as well as by international law students that may be hearing us. So at this point, unless you have anything else to add, Yael, I think that this ends the session. And thanks for joining us during this discussion, and we hope that you can keep enjoying the CODIFI conference. Bye-bye.